Good evening. My name is Chuck Iovan. I'll be presiding over this evening's joint hearings between the Malden Planning Board and the City Council Ordinance Committee, July 17th, 2023. We got a couple administrative things to do. The first thing is for those in attendance, under the provisions of the open meeting law, attendees are informed that this meeting is being recorded by Urban Media Arts, formerly MATV. I have not been notified that any other video or audio recording of this meeting will occur. The next thing that we're going to do is we will do our roll call of the planning board, and then we'll pass it over for the city councilors. So starting with Ronnie.
Ronnie Raj Verma, Planning Board.
Risa Gray, Planning Board.
Thodesh Gabrasalasi, Planning Board.
Diane Shuha, Planning Board.
Chuck Iovan, Planning Board.
Eric McCush, Planning Board.
Hold on a second, Eric. There you go.
Eric Henry, Planning Board.
Henry Susi, Planning Board.
Stephanie Stone, Planning Board.
Thank you, and we'll pass it over to the councilors.
Peg Crow, Ward 1 City Councilor.
Barbara Murphy, Ward 5 City Councilor and City Council President.
Craig Spatafor, City Councilor Lodge.
Thank you all very much. I'm going to ask Diane to read the notices for the four council papers that we'll be reviewing.
The Malden Planning Board and Malden City Council Ordinance Committee will jointly hold a public hearing in the Herbert L. Jackson Council Chamber, Malden City Hall, 215 Pleasant Street, Malden, Mass. At 7 p.m. on Monday, July 17th, 2023, in accordance with Title 12, Chapter 32, Section 050 of the Code of the City of Malden regarding petitions for zoning amendments as proposed in City Council Papers number 197/2023, 198/2023, 227/2023, and 236/2023, to further amend the following sections of Title 12 of the Code of the City of Malden, MCC, as follows. A, Section 12.08.020 MCC Zoning Map, CCP 197/2023, to amend the zoning map to change the zoning district from highway business to neighborhood business for the following parcels. 5 Island Hill Avenue, Assessor's Parcel Identification Number 044-855-505A. 1038 Main Street, Assessor's Parcel Identification Number 044-855-510. 1100 Main Street, Assessor's Parcel Identification Number 044-855-507. 1128 Main Street, Assessor's Parcel Identification Number 044-855-506. B, Section 12.12.030 MCC Use Regulations, CCP 198/2023, to amend use regulations to prohibit self-storage facilities in the Industrial 1 and 2 zoning districts. C, Sections 12.12.030 and 12.12.150 MCC Use Regulations, CCP 227/2023, to amend use regulations to prohibit drive-throughs in the neighborhood business and central business zoning districts. D, Section 12.28.140, subsections B, C, D, F, J, MCC, CCP 236/2023, to amend use regulations for the Road Quarry Reclamation and Redevelopment District, the RQRRD, Subdistrict RQ3, to allow multifamily residential use, establish requirements for affordable and age-restricted housing, and general requirements for development, and amend dimensional regulations and parking requirements, and to amend use regulations for RQRRD, Subdistricts RQ1 and RQ2 to set a 6-story maximum height for multifamily dwellings.
Thank you very much, Diane. Michelle, is there an update on this on paper? The first one we're going to take up is Council Paper 236/2023. Is there an update on this one, Michelle?
Yes, we did receive a letter from the sponsor of the paper, Councilor Sika.
Okay,
You
Diane,
have a copy of that in your package.
Yes,
can you read the letter into the record, please?
Yes, I have a letter dated July 13th, 2023, addressed to Charles Iovan, Chair of Planning Board, and Councilor Peg Crow, Chair of Rules and Ordinance Committee, regarding the joint public hearing July 17th, 2023, paper 236/2023. Dear Chair Iovan and Chair Crow, it is with much regret to inform you that I am unable to attend tonight's meeting due to recent surgery I had requiring more recovery time than expected. As sponsor of this paper, I request the public hearing on the proposed zoning amendments regarding Rose Quarry Reclamation and Redevelopment District, City Council Paper 236/2023, to be tabled. In addition, after further review, it is my opinion that this zoning proposal requires further revision to address unresolved issues. Thank you for consideration on this matter. Respectfully, Jadine Sika, Councilor Ward 8.
Thank you very much, Diane. So we've had a request by the sponsor of the paper to table this matter. Is there a, Councilor Crowe, does anyone on the council have anything they want to say, or? Okay, thank you. Is there a motion to table this council paper? Eric Henry.
Thank you, Mr. Chair. I motion that we table this council this paper.
Very good. Is there a second to allow the tabling? Eric McCush.
I'd like to second that motion.
Thank you very much. Okay. Now, just so everyone knows, all 9 members that are sitting here will be participating in this hearing. We've got 2 members that are out. So we can start. Michelle, you ready for the vote?
Roll call vote.
Roll call vote.
This is to
We will
table
do-
the public hearing on City Council Paper 236,
We will do a roll
2023.
call vote on each council paper. Okay, go ahead.
So a yes vote is to table. Diane Shuhar?
Yes.
Tawadich Geber Selassie?
Yes.
Risa Gray?
Yes.
Eric Henry?
Yes.
Thank you.
Eric McCush?
Yes.
Henry Susi?
Yes.
Stephanie Stone?
Yes.
Ronnie Raj Verma?
Yes.
Chuck Ioven?
Yes. So this council paper will be tabled to a future date per the request of honoring the request of the sponsor of this paper. Thank you. Okay. The next paper that we're going to take up is Council Paper 197/2023 to amend the zoning map. Councilor Crowe, is there someone that's going to present the paper?
Councilor O'Malley is the sponsor. He's present.
Very good. Oh, give me a second, Councilor.
Hello, everyone. My name is Ryan O'Malley, Ward 4 City Councilor, 706A Main Street. I have some things that I'd like to hand out. May I approach?
Yes.
Thank you.
Thank you.
So my name is, again, Ryan O'Malley, Ward 4 City Councilor.
Excuse me, Councilor, but before you begin your presentation, can you just, for the record, identify what it was that you passed out to the planning board?
Yeah, absolutely. So I just handed out 2 documents, one of which is the zoning map with the area that is looking to be rezoned from highway business to neighborhood business. The second one is images, 2 images. One is looking south, the top image looking south from Melrose down to Malden, and it shows the neighborhood business style development on the Malden-Melrose border. It shows like Bobby C's, there's Jitters, there's a daycare, it has nice plantings, it has patio space, decorative lighting, and it's a retail space. That parcel has parking on the back. And the bottom image is of Route 16 in Everett, more of a highway business style. I apologize to the councilors. If one of the members of the planning board maybe share with the councilors what I'm describing. The bottom image is Route 16 in Everett, more of a highway business type zoning. And really what it's showing there is the juxtaposition and the type of environment that you create based on your zoning. So this proposal was put forward because we have been dealing with, for maybe about the past 6 months to a year, various proposals that are looking to go in this Main Street corridor area that we and the neighbors who are here with me tonight and have come before the Board of Appeals many times feel is not in character with the residential neighborhood. It has nothing to do with the type of business it is. It has everything to do with the fact that we're talking about a drive-through where you are very car-centered, very car-focused, right across from a historic park. We have areas in the community. Personally, I've always testified against drive-throughs. We were proposing to put a KFC on Broadway. I believe I came before this body and spoke in opposition to that. I don't think that the type of community that we're really looking to foster is going to be enriched by drive-throughs. They are very dangerous for pedestrians. They're dangerous for people walking with their child and pushing a carriage. And not only that, they often have fatalities. Not even very far from here on Highland Ave. What's Highland Ave called in Medford? Is it Middlesex Ave? So on Middlesex Ave, where they have their fast food areas there, a resident of Edgeworth was actually killed right outside of that area. So when you have a highway business style zoning, you're really encouraging speeding in cars.
Okay, Councilor, we're doing Council Paper 197, not the one on drive-throughs yet?
Absolutely. So
Okay.
what is being proposed, what we currently have before you is a rezoning of this area from highway business, which is going to be focused on fast cars and car-centered businesses, to more of a neighborhood business. In addition, in tandem with the paper that we're talking about right now, which is to rezone to neighborhood business, we are also proposing prohibiting drive-throughs in neighborhood business. Thank you for that clarification. So the real gist of it here is to really encourage the type of business and development that you want in that neighborhood. It was very clear from the residents and the overwhelming thought of the community that this type of business is not great in this neighborhood. If this was a traditional restaurant, maybe with parking behind, even an extension of the businesses that you see up on the Melrose side of this corridor down into Malden, that would be in the character of the neighborhood. But having a drive-through type use in this area is not, which is why we're proposing not only to rezone this to neighborhood business, but to fix neighborhood business to make sure that it is not drive-throughs are not allowed in that neighborhood. If you have any questions on here.
Okay, thank you, Councilor. I appreciate that. I do have one question. There are 4 parcels associated with Paper 197. 2 of them are already existing multi-family housing. Did you consider flipping those 2 from highway business to one of the residential BOCs, as opposed to flipping all 4 of them to neighborhood business? I guess where I'm going, in looking at it, I would have thought that because they have the existing apartment complexes there, and those are the only thing on 5 Island Hill Avenue and 1038 Main Street, did you consider flipping those into residents from highway business instead of to neighborhood business?
So if you look at the map, there's about 4 contiguous parcels that are proposed to be rezoned. It is already a block of zone there. So the proposal has always been to just change that block of zoning. Another reason for maybe not doing that is one of the parcels is a underutilized parking lot that is right on Main Street. There's always a potential in the future that could be redeveloped into a retail business in line with the neighborhood business style. I don't know if that is actually even possible, but we definitely didn't want to just be picking like 1 or 2 parcels. There's a block of zone there, and we thought it was most prudent to change the entire block.
Okay. Did you have something, Michelle?
Oh, I was just going to add that parking goes with the multifamily residential. That's
Understood.
on the same parcel, so that's parking that's required for that housing. It couldn't be converted to anything else.
Under the current zoning, but we're in the process of doing the MBTA community zoning, so there's a chance that parking requirements could change either now or in the future. And I'm not saying that that's a proposal, but it just doesn't make sense to pick and choose 1 or 2 parcels. It really does make sense to go based on contiguous blocks, and that was the focus here. As you can see through the rest of that map, this is like really out of character that this area would be highway business. And maybe in the 1960s or 70s when we were first rolling out zoning, Main Street might have been considered a highway, but I think even then it was a stretch. It is absolutely not a highway now. And I don't think that we should be encouraging development that is specifically geared towards highways in a residential neighborhood like Main Street.
And to that point, Councilor, when the IHOP was there, which is now housing, and when Armatron was there, the manufacturing facility, I think it made a lot more sense that it was considered highway business. But we've since flipped our commercial base into housing.
Yeah, 90% of our community is residentially zoned is like Residence A. I think like a very high percentage of it. And so like obviously a rezoning of a grander scale probably is something we would do in a master plan. But this is really geared towards the fact that where this parcel currently is just not in fitting with the direct abutters of residential neighborhoods. You know, and I'll give you the perfect example. You know, the residents of Main Street, of which I am one, very far from it, but I am a resident of Main Street also. We are used to noise. We are used to cars driving. But I do think it's very different to go from a business that is primarily operating during the daytime to a drive-through that could be open until 1 or 2 in the morning, particularly when you're talking about having an intercom on that directly abutting a residence, and you hear people ordering, I'll take a number 3, I'll take a number 4. It really is not in fitting with the neighborhood. I'm a pro-business counselor. I like development. I like seeing buildings be built. I like seeing grow in the local economy. But I do think one of the things we need to do is make sure that our zoning reflects what we want. Ideally trying to make it so that people don't have to fight tooth and nail. But if our zoning doesn't reflect what we want, then people end up spending a lot of money and time that is wasted. And I don't think that's fair to the developers. I don't think it's fair to the property owners. They should be able to know what we want in a neighborhood so that when they do have a proposal, myself and my colleagues and the planning board and the neighbors can come out and support that because that's what we want.
Okay, thank you. Does anyone else have any other questions for the petitioner? Okay, go ahead, Michelle.
Just had one comment. I just wanted to note, the map that was handed out is from 2017. In your package, you do have the current zoning map. There are a couple changes on it, not for this particular area, but I wanted to make sure everybody was aware. This isn't the current zoning map.
And my
That's
apologies
okay. You
on
should
that.
look at the one in the package, just in case you're referencing or looking for anything else.
But as you say, it's accurate with regard to the area that we're talking.
For that, right. But, you know, it's missing the marijuana establishment overlay district. It's missing parts of central business and a couple other things, so.
Okay, thank you very much. Does anyone else in the planning board have any questions for the petition, the sponsor of the paper? Does anyone on the council ordinance committee care to speak or ask any questions?
Actually, thank you, Mr. Chairman. I just have a question about hospitals. Would the use of the term hospital here include the veterinary hospital?
Yes,
Okay,
yes.
so it's not
So,
just-
yeah, you're looking at the use regulations chart, yes. So hospitals is for people or animals, right?
It is for people and animals.
Right,
okay.
which it is different from kennel, though. Kennel is a separate use.
Because my understanding is that, you know, the Pine Lakes Animal Hospital is looking to rebuild on that site, so I just wanted to make sure there would not be any issue for them, should this go through. Is that a correct assumption?
Yeah, I believe they would have to go through, you know, the regular permitting process, and they potentially may need a special permit or variance. I'm not sure if they're pre-existing non-conforming the building itself, or if they have the parking, et cetera. So, you know, that remains to be seen. I've heard of that, a while ago, I heard of a proposal like that, so.
Okay, thank you.
The kennel actually now, I believe, does need a special permit. They were exempt. Just for everyone's reference, if I may, Mr. Chair, what's highlighted are just the differences between neighborhood business and highway business. Everything else means it's the same. But the use regulations would not be changed, whether the property's classified as neighborhood business or highway business. I've only highlighted where it's different. So, for example, like I'm talking about kennel. Kennel requires a special permit, whether it's in highway business or in neighborhood business. So that particular proposal the council's talking about would need a special permit for the kennel.
Okay, thank you. Eric McCush.
Yeah, thank you, Mr. Chair. This is more of a question for Michelle, I think, but if, I mean, really, the one parcel that they were looking to put the drive-through in, if they had just tried to do zoning on that one spot, that would be, in one location, that would be spot zoning, and that wouldn't be allowed, so is that part of the reason?
It may be, rezoning a single parcel doesn't automatically make it spot zoning. It frequently is spot zoning, because typically it suggests that you're treating that parcel differently from the surrounding parcels. I'm not sure if that was the reasoning behind this proposal, but I guess that was my other point to you. Just because it includes several parcels doesn't mean it's not spot zoning. It can be spot zoning whether it's one parcel or multiple parcels, and it can be not spot zoning whether it's one parcel or multiple parcels. Okay. So,
thank you.
Yep, thanks. And that's the 1100 Main Street that you're asking about for everyone's reference. It's currently motor vehicle repair shop. Also in your package, Eric was talking about the parcel map that I gave you that highlights the 4 parcels.
In comparing the use regulations, what it appears to me, just comparing the two, is it can significantly add to the residential base and significantly reduce the options from a commercial perspective.
And that is exactly the reasoning behind it. You know, Upper Main Street is a residential neighborhood, and to encourage more highway business to type businesses is not in the character of the neighborhood. That is the reasoning for this tonight.
Okay, does anyone else have any other questions for the counselor? Ordinance Committee, do you have anything else you'd like to ask? You're all set? Counselor, is there anything else you'd like to present for paper 197?
No, that's all.
Very good, thank you. At this point, what we will do is we will entertain anyone that would like to speak in favor of this council paper. Anyone that would like to speak in favor of City Council Paper 197/2023. What I'd ask you and everyone else, give us your name and residential address for the record, and also sign in so we have correct spellings. That would be terrific. Thank you.
Good evening. My name is Stephen Hayes, and I live at 12 Fairlawn Street. Probably about a 45-second walk from the parcel, the main parcel under consideration tonight. So I live close by. It's a heavy pedestrian area between the people coming from the park right across the street, people who live in the area. There's a lot of dogs. My family has a dog as well. We've got a young child. Councilor Murphy, we were at your 4th of July party, and it was terrific. Thank you. She won the 3-year-old division for the foot race and the soccer ball kick. It was a good time. It was very nice. And there's a lot of young kids, young families in that area. People with dogs, people coming off the Orange Line at Oak Grove, people at the park. So I think I agree with the sentiments that it's a neighborhood area, and I think that having drive-through is kind of a risky thing to be putting in. It just doesn't really fit in the character of the neighborhood. So I just wanted to take just a quick moment to voice my support. A lot of my neighbors are here. People have lived in the neighborhood for a long time, and I'm just concerned about all of the issues that Councilor O'Malley brought up. Yeah, I just kind of wanted to throw my 2 cents in that I support this and think it's a good idea and would help keep the neighborhood safe most of all. Yeah, that's all. I just wanted to say thank you all for taking the time to consider it.
Thank you very much. Is there anyone else that would like to speak in favor?
Councilors, hi, good evening. Leanne Russell, 3 Fairlawn Street. I have Fairlawn Street, our house is on the corner of Fairlawn and Main Street, and we are abutting or very close to the parcel that's in question that we want to rezone. Fully in favor of making this a neighborhood business. I think if you look at the images that Councilor O'Malley showed you of mixed-use residential that they have right over the border in Melrose, that's definitely in keeping with the style of what we want for that neighborhood, right? It's a highway business. We're talking about 300 feet. That's less than the length of a football field. There are 664 residential units, either within or abutting that. 550 in Windsor Apartments, 114, I believe, in the Pine Banks Village. Our house is 2 houses away from Pine Banks Village, so very familiar with this area. A high pedestrian corridor, as my neighbor mentioned, and I just think that. Again, this would be the right approach to support both businesses and additional residential development within this space. Thank you.
Thank you very much.
I'm Denise Russell, and I've been at 3 Fairlawn Street for 55 years, so I've seen a lot of changes in that area. The businesses that are currently on that strip there on the Malden Melrose line have been very comfortable for the neighborhood, but it is a family neighborhood, and I think that people who decide to purchase something in that area are happy to have a house with a lawn, a place to walk their dog, and not a business that's going to create a hazard. And a drive-through restaurant is a hazard in that area with so many people hiking, walking. You've got a ball field entrance to the park. You have bus routes, you have people crossing the streets there into the apartment complexes. I'm not too clear on what regulations and zonings go with the apartment complex. To me, that's still a residence area because it's people who are working and enjoying the area right there. We are subject to a lot of traffic, foot traffic coming from the MBTA, a lot of car traffic coming off of 93, Route 60, people heading north and south in the morning, north in the evening. It's just, I just think that would be a nightmare. And I'm more concerned about the safety and someone really getting hurt there with that sort of a business. There have been businesses there over the years, as you mentioned, the automatic radio, but that whole area behind there was pretty much warehousing with the business in front. There was for a very short time the Pancake House, but there really wasn't anything else in that area at the time, so the structure of the neighborhood was completely different. Now, it has changed over time. And I think that when you consider what families want when they move to Malden, they're looking for a nice, safe place for their children, activities. They want to support the community, and I think that's very important, to have neighborhoods where they're supporting your churches, your local businesses, your food service, your sports and athletics. That's all about the community. So I'm in favor of some sort of a neighborhood restriction in terms of what kinds of businesses you can have in that particular stretch. I don't quite understand the difference between business zoning and neighborhood zoning. Neighborhood, to me, is going to be less dense with aggressive business versus what's something I would expect to be on Route 60 or 99, for example. Thanks.
Thank you very much. Is there anyone else that would like to speak in favor of this petition?
Hello, my name is Charlene Johnson, and I live at 13 Fairlawn Street. I'm in favor of this ordinance as well. And like my neighbor said, it all comes down to, traffic and just being, a tight area. Main Street gets very, very busy. I mean, a lot of people, may not know that, but it does. And cars, come down our street when, of course, the light, they don't want to wait there. And two of our neighbors, actually haven't said it, but they've actually had cars not only in their house, but also in their yards. So it gets to be that kind of thing. I just think it's just too, tight to have a drive-through there. I liken it to the Wendy's on, I think it's Highland Ave. You go in there and there's like an incredible amount of cars. And, when it's time to leave, you can't get onto the highway. And so I see something like that happening. And that's all I have to say. Thank you.
Thank you very much.
Hi, my name is Narvinder Malhotra. I have lived in the area about 38 years. What I see is that this is going to be very dangerous for the area. Just imagine if people have to come from the other side of Oak Grove, what street they will choose. They will choose from Winter to Autumn and Fairlawn Street. And I live at the corner of Fairlawn Street and Main Street.
And are you right on Fairlawn or are you on Main?
Huh?
You didn't give your residential address. What's your residential address?
4 Fairlawn Street.
Thank you.
Okay, which is corner of Main Street and Fairlawn Street, okay? So now, we will have to put up with the traffic from the other side coming through our street. Why would they want to come from Winter Street to Main Street and then go through two set of lights in order to get to this drive-in, place. So we really feel that our neighborhood peace will be disturbed and made more dangerous. I second everything, whatever has been said, and so I urge you to consider not do it what has been asked to do, for the proposal. Thank you. Bye.
Thank you very much. Anyone else that would like to speak in favor? Yeah, but if you can come up to the microphone, that'd be terrific. Thank you.
Good evening, everybody. Nice to see you all. Do I have to put my name again? Okay. Thank you for this opportunity given us, but we humbly request.
Excuse me, can you give your name and
Okay.
address?
All right. We humbly request to each one of you just to think about it, and it's whatever was said is nothing but the truth. And we don't want to more problems and dangerous, and we all walk around in the neighborhood, and we have so many children, you can say 0 to any age, and we want to keep it safe. And you have, please think it over and invite some nice place better than any of these walk-to restaurants. And because many restaurants or business is open, and everybody has their liberty, and they can come and choose anytime they please. And I don't know how many people will be considered about the noise at middle of the night. And it creates more headache and problem for each one of us. So we'd like to request you, please, give us an opportunity not to. You have the authority, you have the right, but please humbly request, listen to us a little bit. Thank you very much. Enjoy the summer.
Can you just say your name for the record?
Rama Malhotra, number 4, Fairlawn Street. And you'll be seeing me. We have a beautiful garden in the corner, so I'll be running around.
Oh, I appreciate it. Thank you.
Yes, right in the corner. You cannot miss number 4 Fairlawn Street and 3 Fairlawn Street. Thank you very much.
You're welcome.
Have
Thank
a good
you.
summer.
Have a good evening.
Thank you very much. Take care.
Is there anyone else that would like to speak in favor of this petition? Michelle, is there anything to read in favor? Oh, we look like we have someone here.
Hi, I'm Susan Lawrence, 176 Glenwood Street, and I'm here for aesthetic reasons. I just feel like Malden gets eaten up by businesses that are big and ugly, and a lot of people come and drive in and out, and I don't like it. It's a lot. There's a lot of chain things coming in, and it's aesthetic. I'm not here to talk about safety. Other people have done that, but that's why I wanted to show up. It's just not the direction I want to see that part of the town go to. I go by there, and I don't want to look at a fast food place, so that's what I've got to say. Thanks.
Thank you.
I should also add that I do use the restaurants that are there now, that are the small-scale places. I often go get sushi or something Italian or whatever is around there, and I think that's the Jitter's place. There's a way to have some things to eat that is a little more low-key, and that's what I would like to see us move that way.
So you enjoy the offerings in Melrose, but you think that a fast food place is just a little too much?
It isn't my vibe. It's its own aesthetic for me, but that's personal. But are those in Melrose? I didn't know which town is which right there. So,
Yes.
I mean, it's kind of, let's keep with the vibe is my, I didn't even know that.
that's what I said.
Thanks.
No, thank you very much. Anyone else that would like to speak in favor? Michelle, is there anything to read in favor?
No.
Thank you very much. At this point, I declare that portion of the hearing closed, and I would like to entertain anyone that would like to speak in opposition to Council Paper 197. Those in opposition. Same drill, name and address for the record, please, and sign the clipboard.
Good evening, Mr. Chair. If I could, I'd like to pass around a letter from which I'll be reading.
Yep, very good. Thank you. Thank you.
That would be the second time Council Spatafora saw me trip down those stairs.
I saw nothing.
Good evening, Mr. Chair. Good evening, Council President, members of the City Council, members of the Planning Board. My name is Roberto DeMarco. I represent the current owners, James and Robert Salona, trustees of the Salona Real Estate Trust of the property located at 1100 Main Street, Malden. I write to you concerning the above referenced proposed ordinance change. As detailed herein, this proposal is a violation of law insofar as it is clear spot zoning and disparately impacts my client's property. The actions by the City of Malden in bringing this proposal forward have already caused financial harm to the property owners, arguably already meet the prima facie case for compensation as a regulatory takings by the city. And I urge that this ordinance change be rejected immediately to stem the already significant financial harm it has caused. The area zoned under the classification of highway business consists of 4 distinct parcels. All of the uses of the parcels have been in place for several years. 2 of the parcels, 5 Island Hill Avenue and 1038 Main Street, are utilized as multifamily dwellings. The parcel at 5 Island Hill Avenue consists of 3 large multifamily residences and is part of the much larger Oak Grove Village built in Malden and Melrose by Fidelity Investments beginning in approximately 2002. The parcel at 1038 Main Street, Pine Banks Village, consists of 14 residential buildings built in approximately 1985. The parcel at 1128 Main Street, occupied by Pine Banks Animal Hospital, has been in constant use as an animal hospital and kennel since at least 1971. The last parcel at 1100 Main Street contains my client's business, Pine Banks Automotive Center, which has operated since 1975. These 4 parcels are among the most stable and long-term uses in the city. At no time in the past almost 50 years, even at the construction of the 2 residential developments at 1038 Main Street and 5 Island Hill Ave, has there been any action to change the zoning of the area in a way that would invalidate the current uses. These discussions only began when the proposed purchasers of the property, Popeye's Louisiana Chicken, submitted their request for a variance in November 2022. Then at a hearing of the Zoning Board of Appeals in May 2023 and June 2023, the ZBA denied the requested variance. And as a side note, I understand that there are some meeting on that in order to confirm that denial, but they did not pass. Simultaneous with these hearings, in May 2023, the proposed ordinance was filed. See Malden Ordinance File 19723. The proposed ordinance would result in a change from highway business to neighborhood business for the 4 parcels. While on its face, one could argue that because this applies to the entire district, this is not spot zoning, this argument fails on closer inspection. The change to neighborhood business would only impact my client's property, quite contrary to the rationale listed in the ordinance change, which states that the amendment is intended to, quote, better reflect the current uses. Those current uses, as defined by the Malden Municipal Code 1212-030, show that the multifamily residences are the same under both zoning classifications, as is hospital and kennel. In fact, the change from highway business to neighborhood business results in automotive repair being a disallowed use, the only substantive change for the 4 lots. As such, the stated rationale is fully pretextual, hiding the real reason. While the zoning change would not require the current use to be discontinued and would not force the business to be closed, it would categorize the use as a pre-existing non-conforming use under Malden Municipal Code 1228-010, which applies additional conditions to the use as detailed in 1228-010E. These are not conditions which apply to the other 3 lots. Additionally, the change from highway business to neighborhood business would prohibit 18 other currently allowed uses, negatively impacting the marketability of the lot. It is well known that the current status of the property is as a for-sale property. The impact of the proposed change has already cooled interest, and the value of the offers has reduced. The current proposal was clearly made in reaction to the failed application for a variance. The companion proposed ordinance change prohibiting drive-throughs in the neighborhood business area further supports this fact. In addition, I would point you to the testimony tonight, which focused purely on my client's lot. Taken together, the action is improper and should be rejected. When these facts are viewed in the light of the applicable laws in Massachusetts, the result unambiguously supports the rejection of the current ordinance change and places the City of Malden on notice that it is acting in a manner that directly threatens the beneficial interests of my clients, leaving the city liable for potential financial damages. It is quite clear that the current attempt to change the allowable uses is a direct, unambiguous reaction to my client's attempt to sell the property and retire. Quote, it is unlawful to invoke the zoning power solely to confer an economic benefit or impose an economic detriment upon the owner of a comparatively small area within a zoning district when the remaining parcels of that district are treated differently. Cases cited. The proposed change would have no other reason in such a small zoning district than to impact the sale of the property. As such, it is an attempt to devalue and regulatorily take my client's property to prevent them from realizing the long-term benefits of their almost 50 years of ownership. The fact that the proposal is for more than one lot is also not definitive as a protection against spot zoning. This case is cited. The city's attempted action is directed at a change that singles out these lots in an attempt to interfere with the contemplated transaction and not for a legitimate purpose. It is well known that the courts will afford great deference to municipalities in exercise of their powers. Quote, with respect to the exercise of their powers under the Zoning Act, the courts accord municipalities deference to their legislative choices and their exercise of discretion regarding zoning orders. Apart from limitations not relevant here, the Zoning Act generally permits cities and towns to adopt any zoning provision which are constitutionally permissible. Cases cited. But this deference is not absolute, and a showing that the actions are not supported or measured can result in a finding against the municipality. The constitutional test is whether the bylaw is clearly arbitrary and unreasonable, having no substantial relation to the public health, safety, morals, or general welfare. An amendment will be sustained unless there is no substantial relation between it and the express purposes of the Zoning Act. Conversely, it will be held invalid if it is arbitrary, unreasonable, or substantially unrelated to public health, convenience, morals, or welfare. Here, as detailed above, there has not been and cannot be any showing of a relationship to the public health, safety, morals, or general welfare, as the change is not one which has been required for the last 50 years and does not impact any other property except for 1100 Main Street. After a recognition that the action has no other legitimate reason than to detrimentally impact the property owner, the logical next step is the recognition that this action leads to a right of compensation by the property owners. Quote, while the takings clause is directly primarily at direct government appropriation or physical invasion of private property, the Supreme Court has recognized that the government regulations of private property may in some instances be so onerous that its effect is tantamount to a direct appropriation or ouster, and that such regulatory takings may be compensable under the Fifth Amendment. Cases cited. Here, the removal of 18 major zoning uses is clearly an economic impact to the potential sale of the property. The very act of filing the requested ordinance change has already caused a demonstrable drop in the value of the property. Quote, when the regulatory taking involves neither physical invasion nor complete deprivation of use, as the case here, federal law has established several interrelated factors which are considered in determining whether a compensable taking has occurred. One, the economic value of the regulation on the claim. Two, the extent to which the regulation has interfered with the distinctive investment-backed expectations. And three, the character of the governmental action. These factors are all met with ease by the property owners, even this early in the ordinance amendment process. First, the sale of the property has been impacted, not just for the variance petitioner, which I would add, as an aside, has already failed. The ordinance works as intended. The neighbors do not have to worry about a drive-through. That's why we have the ordinance set up the way we do. Second, the property owners have had a continuous use of the property for almost 50 years and have a reasonable expectation they could sell such uniquely situated property to a wide variety of investors, a class that has been effectively whittled down by the proposed change. This leaves us with only the third element to consider as to whether compensation would be owed. This third element is also easily met when one realizes that the proposal was not afforded appropriate due diligence. As was the case in National Amusements, Inc. versus City of Boston, it is striking that there was a complete absence of analysis of land use planning considerations by the municipal authority before the decision to change the zoning was taken. In fact, Massachusetts case law has a very negative view of reactionary zoning. The courts have opined that under our cases, zone changes which have no roots in planning objectives, but which have no better purpose than to torpedo a specific development on a specific parcel, are considered arbitrary and unreasonable. The current proposal's inception came about due to the application for a variance by the proposed buyer. Though the variance was denied, the city has clearly decided it would forestall any other future applications by changing the zoning to torpedo further sales that may be to one of the 18 categories discussed above. When read together, these cases and others discussing spot zoning support the position that the current proposed ordinance change must be rejected immediately, as it has already realized financial harm aggravated to the point where the action for reimbursement is the only course of action left available. The matter has already resulted in establishing a cognizable case for compensation. To do otherwise, to continue down this line and lend any credibility to the current course of action by allowing this proposal to move forward, would be to endorse these actions and in the face of financial liability, telegraph that the City of Malden desires to use its powers of regulation to take from small business owners their property rights. Such a message can only lead to claims for compensation and litigation, a result that should be avoided. For the purposes set forth herein, I request that the Planning Board recommend a rejection of the proposed ordinance change under CCP 197/2023 to the City Council. I would also add, you have heard testimony from the neighbors, testimony from the plan proponent, that focus on the drive-through. It's the drive-through. You've also heard that this business has been there for 50 years. You will negatively impact this business. You can't simply change zoning because of a sale. That's not the way it works. It's supposed to happen in consideration of the neighborhood. Now, granted, there have been considerations made tonight. There have been comments about what it looks like as compared to Everett. But nothing's changed in 50 years for this lot. The other 3 lots, one, the animal hospital, hasn't changed in longer. The other 2 changed and became residential. That was allowed before. There was no zoning change. They went through the process, they got approved. I sat on the Conservation Commission at the time of that proposal. There were other proposals that were going forward. The best one happened because the neighbors spoke, as they spoke the other night at the variance. The ordinance works the way it's intended. They didn't want a drive-through. That's what they spoke about tonight. My client has an auto body. The minute you change the ordinance, he will become a disallowed pre-existing use. And this board knows that that is a difference. If something happens to his business, he must go through the special permitting process. It's different. You are going to affect his property rights, and it's only his property rights. You can't let this go forward. You must recommend against it. There are less restrictive ways to control this type of development. That's what this board is about. It's about using the least restrictive manner to control. The neighbors are active. They don't want something, they'll come out and say it. It is already in place. Drive-throughs are not allowed by right in any district in this city. They are all special permit. And a special permit must be in harmony with the general purpose of the area under 40A Section 9. This board knows that provision better than anyone else in the city. And lastly, I would say, I too have played at Pine Banks when I was a kid. My kids have played at Pine Banks. I know the area. It has changed. But this business should not be negatively impacted because it was long-term. We want businesses like that. He's not looking to, these gentlemen are not looking to harm the neighborhood that they were in. They put a proposal forward, it was rejected. We move on. But reactionary zoning to this is the wrong way to go. It should be to follow through with the ordinance as written and not in reaction to any one proposal. Thank you for your time.
Thank you. Is there anyone else that would like to speak in opposition to this council paper? Anyone else? Michelle, do you have anything to read or to be read in opposition?
No.
Seeing and hearing no one else that would like to speak in opposition, declare that part of the hearing closed. Michelle, will you take us through your staff report, please?
So this is regarding City Council Paper 197 of 2023. You have a copy of the amendment in your package. We've heard from the sponsor. These are the 4 parcels that are involved. I've given you the breakdown. I'm reading from the planning report and recommendation dated July 17, 2023. I won't read everything verbatim, but it is incorporated herein by reference into the record of the hearing. As I mentioned before, you do have a parcel map and also the current zoning map showing the parcels. We did not receive a legal description yet of the subject properties. That needs to be prepared and included with any amendment of the zoning map that is ordained. So that would need to be done before the City Council considers ordaining anything. Current zoning, we've heard the properties currently classified as highway business zoning. That has been since 1977, when the zoning was first adopted. The Residence A zoning district abuts to the south, east, and west. The direct abutters to the north are multifamily residential dwellings in Melrose. To the east, on the other side of Main Street, is Pine Banks Park. To the south, single and two-family dwellings. To the west, the Spot Palm Brook Culvert, on the other side of which is the Oak Grove MBTA Rapid Transit Station. Surrounding land uses are residential and the Forest Hill Cemetery. We have heard, I do want to just briefly mention, we've heard a lot about the one property, 1100 Main, but, you know, as we heard in the initial presentation, this is a proposal to rezone 4 different parcels, not just the one. In terms of use regulations, I've given you the current table of use regulations so you can see what's allowed by right, what's allowed by special permit, and what's prohibited in the current zoning district and in the proposed zoning district. As I mentioned earlier, the highlighted items are showing you where there are differences in the use regulations. You should look down both the columns though, NB, or BN, which is neighborhood business, and BH, which is highway business. So there are regulations for all these different uses. Yes means it's allowed by right, no means it's prohibited, and SP means it is allowed or may be allowed by special permit. In terms of dimensional controls and parking requirements, it is the use of the property, not the zoning district, that determines applicable dimensional controls and parking and loading requirements. So there's no proposal to change any parking, loading, or dimensional controls, just the use regulations. In terms of applications and exemptions, the amendments will apply to new construction and new use of occupancy of existing buildings unless exempt by Mass General laws, the city zoning ordinance, or the express language of the amendment, or is the subject of a building permit or special permit issued before the first publication of notice of the public hearing. The first publication was June 30th, 2023. Per state statute, applications for permits in the processing stage when publication occurs are not protected. Historically, the city interprets, in consideration of a petitioner's good faith reliance on the current regs, that proposed amendments would not apply to applications filed prior to first publication of the notice of public hearing date above. We've heard about this application. There's an application for a fast food restaurant with drive-through at 1100 Main Street, and that was filed prior to the first date of publication of the hearing notice. It is still in the processing stage. It did have a public hearing by the Board of Appeal, and it is my understanding that the variance was denied. Petitioner, you heard during some of the public testimony that there's a follow-up meeting to, I guess I would say, to clarify that that was the decision to deny. That is coming up this week, but it is my understanding the variance was denied. That property is the subject of this amendment. Again, it's 1100 Main Street. If the zoning district were to be mentioning this, not only in relation to that permit application, but if the zoning district were to be amended to neighborhood business, the property would also be subject to amendments to prohibit drive-throughs, which is paper 227 of 2023. We'll hear the public hearing on that tonight as well. The effective date of an amendment is the date of the city council's vote to ordain the amendment. The council must act on the amendment within 90 days after the public hearing closes, otherwise we'll need to do a new public hearing. So if the public hearing closes tonight, the final date for action would be October 15, 2023. In terms of the standard of review, the planning board's review and recommendation of the proposed zoning changes should be directed by substantive planning objectives, community need, and general welfare. In the current zoning district, there are numerous industrial uses in potential conflict with surrounding land uses that are allowed by right or by special permit. This amendment would reclassify the subject properties to a zoning district in which those uses are prohibited. You will be making an advisory recommendation to the city council. It will be up to the city council whether or not to amend the zoning ordinance. Your recommendation is advisory, so they don't need to follow it, but I did want to mention that a recommendation to disapprove does carry certain weight. If you were to recommend a disapproval of a zoning amendment, this or any other one, and that amendment were then to receive unfavorable action by the city council, there would be a 2-year prohibition on considering that same amendment. So, wanted to mention that. The recommendation, which was made prior to the public hearing, do you want me to go forward, or
Yes,
do you
please.
have questions?
I don't see anyone else has questions, so if
Okay.
you could go forward,
Would be
please.
that the planning board recommends to the city council approval of the proposed amendment of section 12.08.020, which is the zoning map, and 2, to prepare a legal description of all property land that is the subject of the amendment and include with any amendment ordained. So that was the recommendation that you would make to the city council. Or that's the recommended recommendation.
Thank you very much, Michelle. Eric Henry.
Thanks, Mr. Chair. You did ask if there were any other questions. I don't know if it's appropriate or not at this time to ask, and maybe this will be discussed in one of the other papers, but it was mentioned by Mr. DeMarco about these 13, correct me if I'm wrong, 13 number of ordinances this is going to affect?
What was mentioned was the 18 uses that would no longer be an option for these 4 properties. And what he's referring to is if you look at the table of use regulations,
Yep.
and you see right now in highway business, there are certain uses that are either allowed by right or allowed by special permit. If you look at the same uses in neighborhood business, those uses are now prohibited. So those are the 18 that he's referring to. Club Lodge is one, hotel, motel, recreation for gainful business, secondary to principal club lodge, fast food restaurant, planned development, substance abuse treatment center, adult day health center, marijuana retailers, building construction contracting, motor vehicle repair shop, warehouse, research and development, towing, and then the 5 marijuana industrial uses, cultivator, testing laboratory, product manufacturer, research facility, and transporter. So those are the 18 different business and industrial uses that would change. So now, if you're in highway business, you can apply for special permit, or it's allowed by right. If you're in neighborhood business, it's no longer an option.
Thanks for reading those into the record, Michelle.
Yes, no problem.
Are there any other questions for Michelle? Ronnie Verma. Okay. Oh, I'm sorry, Barbara Murphy.
Thank you. Yes, Michelle, I'm still there. My engineer. So if I'm interpreting this correctly, are you saying...
Excuse me,
I'm sorry.
Council President Murphy.
Speak into this.
Don't feel compelled to look at us.
Yes.
Speak into the microphone so the
I know
audience
better.
hears more. Thank you.
Sorry about that. It's just hard to have you back to someone. Ms. Romero, so my question is, the use, motor vehicle repair shop, the gentleman owns a motor vehicle repair shop today. It's operated for 50 years as a motor vehicle repair shop. If this ordinance passes, he would not be able to sell his, I know it's pre-existing, it could possibly be considered pre-existing non-conforming, but what would be the situation when, if he sold this business to someone who wanted to continue on in that use? Are we saying that that use would no longer be allowed?
Well, what we're saying is that that use actually, even though it is allowed by special permit, is considered a pre-existing non-conforming use because it does not have a special permit. All four of those properties actually have pre-existing non-conforming use statuses because none of them receive special permits and all of the current uses require a special permit. So they all have a pre-existing non-conforming use status. The difference is his motor vehicle repair shop would no longer be allowed in neighborhood business. So the use could continue, the use could possibly be extended or altered, the same use, by special permit, but there could be no change of use to any of these other 18. So he can continue his business as long as it's legal and it's lawful, which I understand he does have an occupancy permit, so it is.
Well, my question is more if he sells it.
He can sell it in another motor vehicle repair shop, can operate there.
Okay. Okay, so they could operate.
Yes, the same use can continue, or again, by special permit, could possibly be either reconstructed or extended. You know, it would need a special permit to do those things. But what he couldn't do is sell it for one of these uses that's no longer allowed.
In your recollection, have we ever, I'm just, you know, obviously Mr. DeMarco made made me think of this differently than I was thinking of it when I walked in the door. Can you ever recall a situation where we have changed zoning like this and it's really only affected one business?
We've changed zoning for different individual parcels and collections of parcels. So I would definitely say ones where only a single parcel was changed, that would have been the case. I can think of probably at least one, if not two. Now, one example I'm thinking of, though, the zoning was changed and the redevelopment of the property was now allowed to occur under the new zoning. Under the old zoning, the particular case was it was changed from industrial to residential. Residential wasn't allowed in industrial. It was now allowed because it was in a residential district. So there are examples where that has happened. This is a little, you know, usually you see the example or you hear of spot zoning where somebody, you know, the new property or the property's accruing a benefit. In this case, that would be they're suggesting it will be to the detriment of that particular property. So, I mean, I want to just add, every case is unique, every case is, you know, individual. So you need to, you know, look at this for the merits of it. And, you know, you should be looking at things like the surrounding neighborhood, the uses. My statement about compatibility, you know, goes to all the different things that go with compatibility of uses. Traffic patterns compatible, parking patterns compatible, use, hours of operation, you know, nuisance, health, safety, things like that. So I just use the word, you know, the phrase compatibility of uses or conflict of uses, but it, you know, includes all those different types of factors that you would want to consider.
Thank you. You know, I do get where I think this is a very unique situation. I guess that's what I'm getting at. You know, having sat here for many years and looked at zoning, this one seems to just have some nuances to it that, you know, I'm not used to seeing with an impact that seems to be a challenge, I will say. So, thank you.
Thank you, Councilor. Does anyone have any other comments or questions that they might have? Councilor Spatafora.
This is a question, Michelle. A drive-through, which seems to be the focus. Can you define a drive-through?
Yes.
Is it only related to food?
No.
So is it a drive-up ATM considered a drive-through?
Yes, so drive-through, if you just give me 1 second, let me get to this definition here. So drive-through is a facility where food, goods, or services are purchased or obtained from a building or structure on the same lot via a window or similar opening in the building or structure and accessed while in a vehicle. A drive-through is accessory to the principal use of the building or structure and operated in conjunction with the same. So that's a definition from our zoning ordinance. So the drive-through is accessory to the principal use. Can be accessory to a principal restaurant use, retail sales use, or an office use. The offices are the bank. Banks are considered general offices. So those are the different categories. I'm not sure if retail services as well. But keep in mind, drive-through is, at least under the current zoning, is allowed by special permit in both highway business and neighborhood business zoning districts.
Yeah, and I do want to say, I understand the frustration, I think, with drive-throughs and certainly maybe the aesthetics. But one thing that came up during the discussions in the council is, you can put a restaurant in based under the new proposal. I think it's under 5,000 square feet, right? Is it under 5,000 square feet gross?
That would be the retail,
Maybe I read it wrong.
sales are allowed by right in both districts. Restaurant, just a regular restaurant, no, it's just by special permit in either district. What's changing is the fast food restaurant.
Yep.
So fast food restaurant is allowed in highway business by special permit. It is prohibited in neighborhood business.
Yeah, and I think my point, and thank you for that, my point is, something I think everybody in this room has realized is, drive-throughs are certainly proficient, but what I've noticed is it's the Uber drivers that are not going through a drive-through to grab there. You can stand at this Starbucks on an early morning, there's no drive-through, but all the traffic is Uber Eats, all the Lyft drivers picking up the food, because now people, McDonald's, they're not using necessarily just the drive-through. All those cars are coming to restaurants because that is a huge revenue source. And I think sometimes we think if we get rid of the drive-through, which certainly would limit traffic, but by having a restaurant there, we could have the same amount of traffic, even though it doesn't have a drive-through window, because we can't outlaw Uber Eats and things like that. And that has been, it's a huge, huge revenue source, and it's a challenge for the city. It is a major challenge for the city, because those are just as dangerous, I think, as a drive-through, just from what I see. Because they never park in their car, right? They're driving up, they're leaving their blinkers on, they're running and getting their bags, and that's causing chaos too. We don't eliminate that in any scenario here, is my point. So just food for thought, I think, not only for this council, but certainly the people in the audience. There are still those challenges that you have, even though there might not be a drive-through there. Thank you.
And I'm sorry, you were asking about the 1,000 square
Yeah,
feet. So, yeah, the fast food restaurant has greater than 1,000 square feet. That's what you're talking about, right? That has a size in it, right?
Under 1,000.
You could have it under 1,000, but not in neighborhood business. Right.
Eric Henry.
Thank you again, Mr. Chair. I hope this is the last time. You know, like the council said, other people have said up there, this is, presents some unique challenges, which Council Murphy said in particular, you know, whether or not this property is, this is an asset or a detriment to the community, and this is being set up as a detriment. But I'm really also keying into what Mr. DeMarco said with regards to, is the process broken? The neighbors have spoken, and they went to multiple variances, and it seems that, you know, that process appears to have worked as it should, and I'm not really keen that the special permitting process that we're looking to eliminate would not work in these similar circumstances as well. So it would be nice if the city solicitor was here to rebut what Mr. DeMarco had to say, but yeah, I just thought I'd share that. Thank you.
Thank you, Eric. Henry Susi. Oh, Stephanie. Sorry about that.
Can I ask about the definition of the drive-through business? And with now a lot of food establishments, fast food definition, a lot of food establishments now do call ahead orders, even if you thought of it as fast food previously. Does something like a Starbucks, it's not a fast food restaurant because they do the call ahead orders, and there isn't a drive-through window. And there could be various fast food, what we think of as fast food, that do those pre-orders now, and if they didn't have a drive-through window, would that be considered a regular restaurant?
Yeah, we do have a definition of fast food service too, and it reads, food and drink prepared in advance of ordering by the purchaser or prepared quick order upon direct instructions to personnel other than a waitress and or waiter, packaged and or containerized other than in dishes for convenience and ease of carrying by the customer, consumed within the structure or upon the associated grounds in motor vehicles and or off premises. So as you're all, you know, kind of talking about, you know, it's clear, and it has been clear for a little while, really, since, as Council Spatafore mentioned, all the Uber services have come into play. Our definition of drive-through and fast food service is, you know, needs to be updated. But in terms of your question, the Starbucks that's there was not considered a fast food. It was considered a restaurant. To my knowledge, most of the Dunkin' Donuts in the city are considered restaurants. They're not considered fast food. There's criteria, this is ultimately determined by the building commissioner, how we use this classified. So I'm not sure if that really helps you, but, you know, a restaurant, this still would allow restaurant, neighborhood business still allows restaurant, it just wouldn't allow fast food service restaurant, provided it meets our definitions, so. And it would still allow drive-through under the current zoning, even though we're gonna hear about a proposal to prohibit it from those districts. Right now, it is still allowed, so just keep that in mind. This paper alone would not prohibit drive-throughs from these 4 properties. This would just change the zoning district so that different options would be allowed on those properties. Although, as I've mentioned a couple times, if you look at this list, there's very few things highlighted, which means everything else is the same. So there's a lot that's not changing between highway business and neighborhood business, or that wouldn't change. That's it.
Is that all set? Did I answer your question?
Is it appropriate to ask too, what does Melrose classify that parcel, the parcel right next to it that has the various businesses?
Those, I don't know Melrose zoning, I'm not sure what it's classified as. All those retail restaurants and services are in Melrose. The line cuts right near that driveway.
You all set?
Yep.
Eric McCush.
Thank you, Mr. Chair. Even before Attorney DeMarco's presentation, this struck me as spot zoning. And we're not talking about drive-throughs right now, we're talking about this one specific parcel. And it just, I personally don't like to see people's rights being taken away from them. If you're ready for a motion, I'd like to make one.
I think there's a couple more people that want to make comments, but hold on. Risa Gray.
I was just looking, thank you, Mr. Chair. I was looking for a clarification on one of the uses. So I just want to understand. So right now, you could not put single-family or two-family residential on that spot?
That's correct.
But you could
Yes.
if it got changed to neighborhood business?
Yes, that is one of the residential changes, right. Single and two families are prohibited in highway business. They're allowed by right in neighborhood business. All the other residential uses are the same.
Okay, thank you.
Yeah. Meaning they're allowed by special permit or prohibited.
The only comments that I'd like to make are basically, this is certainly a neighborhood that has changed in the last 20 years. Once Fidelity put up those buildings, it changed it significantly. PV Speed Shop went out and that became housing. So the feel of this stretch of land significantly changed once Fidelity put up all those units and Malden had their piece of it. So I can see the change in the neighborhood and appreciate that. But what I found compelling was Attorney DeMarco's observation and comments that the process worked. What we heard from mostly was the drive-through. People didn't want the safety associated with the drive-through and all those associated negative points of what was being proposed. So it feels like the system worked from that perspective for the neighbors. Now, the one thing that I'm still struggling with is in this whole proposal, only 1100 Main Street seems to be at a detriment. They have 18, which is approximately 25% of the options. They can't do if this goes through. So that would significantly, I would think, impact the market rate of that property. It's been proposed that the current owners are looking to change, retire, sell it, move on. Now, if they can find one of these other 50-plus uses, then it seems like that would work out for everyone's favor. It would work out for 1100 Main Street, and it would work out for the neighbors. But it just doesn't sit right that they're the only ones. No one on 103.8 is impacted. No one at 5 Island Hill Avenue is impacted, and the Pine Banks Animal Hospital isn't impacted. It only seems to be that 1100 Main Street is. So that's the part I'm struggling with. We've had a lot of input from the neighbors, but that's the piece that I'm struggling with on this, on how we get over that. I have one more. I see Councilor O'Malley would like to say something. If you hold on one second, Diane Chuha had a question. And
Yeah, you pretty much answered my question, so I thank you for that, because my understanding too is a lot of the items in business highway are going to need a special permit. So when the drive-through was going through, the Board of Appeals said no, because they couldn't get the variances. If they did go through, they still have to come before us, correct, for a special permit? We can have the neighborhood and city councilors and everyone speaking in opposition or in favor, and we make the decision based on that outcome. So I'm kind of stuck where you are too, where it's like, it's only affecting these particular people, not, I was wondering why it was just these four, and, was the other properties connected to it already in a different, neighborhood? Is it all?
They're already Residence A. They're in Residence A.
So it's just this portion, that's the only, all right, so you have to pick all four. Okay, yeah, so I was just kind of, what you said was pretty much my sentiment as well.
Okay, thank you. Councilor O'Malley.
Yeah, this has been great discussion. I just wanted to kind of clarify, obviously, Attorney DeMarco's letter was, well-written and I'm sure well-researched. It's never good to be threatened with a lawsuit, and I understand he's representing his client zealously. But as has been pointed out by members here tonight, this really is about making this parcel and these parcels as a group match the fabric and the character of the neighborhood. And that involves allowing new uses, as has been pointed out, as well as removing some uses. All of the other parcels in this zone, as the city planner pointed out, are pre-existing non-conforming. And I'm just going to point out, this was inspired by recent activities, yes, as many things are. We're also talking about whether or not we want to restrict the self-storage facilities. That was inspired by comments that we received from our residents. That was inspired by driving around the community and seeing a lot of these types of uses being put up. So, of course, what we do as city councilors, as planning board, and as a city is inspired of what goes on. That doesn't mean it's inappropriate. It means we're doing our job and actually reflecting based on what we're hearing on the ground. What we're doing is not clearly arbitrary. It's not unreasonable. And I ask, if we don't do something like this now to right-set the zoning so that the proposals that are put forward by any of the property owners would likely get support, when do we do it? Do we do it in 2 years? Do we do it in 5 years? Do we do it in 10 years after the parcel has sat there and nothing has been got through the process? My thought here was I do not want any of the property owners in this area to waste their money putting forward projects that are not going to get the community support. I thought the way that you would do that is to right-set the zoning so that what we put here is actually supported by the neighborhood. And, as was pointed out, if we leave it the way it is, they're going to require a special permit. That's going to require a lot of money on their part to come before bodies. It's going to require a lot of community activating and a lot of residents coming out. It's going to require a lot of activity for y'all. I just think that's a waste of time and energy and money for everyone involved. But if that's what we need to do, we need to do it. I think the way to do this is to set the zoning correct, but I understand the difficult position that you all are in. Thank you.
Thank you, Councilor. Eric Henry.
Thank you, Mr. Chair. I think this will probably be the last time, but if I heard this correctly, residential is not allowed in that area, that zone right now?
Single and two-family residential dwellings are prohibited. 3 and 4 families are allowed by special permit. Town and row houses are allowed by special permit. Multifamily up to 3 stories is allowed by special permit.
So I guess the opposite of making this, spot zoning in a maybe it's an asset if the petitioner, if who Mr. DeMarco is representing were looking to change the zoning such that they could build a 1 or 2 family property on that unit, then would that be considered spot zoning just to accommodate this property?
Well, again, there are different criteria that the courts are going to look at for spot zoning. I'm not going to give you legal advice about spot zoning.
Yep.
But just because it's benefiting a property doesn't make it spot zoning. Just because it's detrimental to a property doesn't make it spot zoning. There are real specific criteria that the court will look at. It is true what the attorney DeMarco said. The courts show great deference to the city. They presume the city knows its own city and its own law. So deference will be shown typically to any zoning amendments. So I don't want you to, I'm not saying you shouldn't consider the spot zoning argument, but you'll just have to consider it for what you've heard. I can't give you any legal opinions on it, and I wouldn't, if you have an issue with you thinking this isn't right for the city or this section of the city or for those properties, for any number of reasons you can articulate, you should base your decision on that. I don't think you should base it on your idea of what spot zoning is or what it isn't. If this were illegal, it was trying to regulate something on its face illegally, there was no question it was contrary to some city or state or federal law that I was aware of, I would have told you that and said, this should not pass, you should recommend again. I would recommend that you recommend against this because it, violates this specific law. The spot zoning is, going to be an interpretation made by the court, so it can't really point to anything in particular. So I'm not saying you should weigh everything you've heard and make a decision.
Yes,
on all those factors.
Cool, thank you very much for that. It actually was along the lines of, as the Ordinance Committee does their deliberation on things that may potentially come before them, you know, maybe that could be looking at that as a potential, another option for our residents, our landowners to be able to exercise their right to do what they wish with their property. So, and that's it. Thanks for the clarification.
Thank you, Eric. At this point, does council have anything, ordinance? Does anyone say? No? Eric McCush.
Thank you, Mr. Chair. I'd like to make a motion to recommend to the council to deny the amendment.
Eric Henry.
I second that motion.
Okay, so the motion has been made that we do not, the planning board recommends not to adopt the council paper 197/2023 as submitted.
So to recommend disapproval to the city council, right?
Correct.
Eric McCush.
Well, hold on a second.
Motion, and then Eric Henry seconded.
Yes.
Okay. You want me to do a roll call vote?
Give me 1 second.
Sure.
Okay, yes, roll call vote, please, but let me get queued up.
Okay, so a yes vote will be to recommend disapproval.
Okay, Michelle?
Diane Shuha?
No.
Tawadej Geber Selassie?
No.
Risa Gray?
No.
Eric Henry?
Yes.
Eric McCush?
Yes.
Henry Susi?
No.
Stephanie Stone?
Yes.
Ronnie Raj Verma?
Yes.
Chuck Iovan?
Yes.
So that motion carried 5-4. You needed a majority to make that recommendation. So we will make the recommendation to the city council, or I will make it for you, put it in writing that you recommend disapproval. I will note that it was a 5-4 vote.
Okay, thank you. Okay, so that ended at 8:40. We're going to do the next one on the docket is self-storage units. Okay. What's that? Yes. Council, we're just going to give Councilor Crowe a moment. Yeah. No, you can go. Okay, Counselor O'Malley.
Has the paper been read?
Yes, paper was read at the beginning.
Oh, sorry. So again, for a reminder to the honorable members of the planning board and the public, this is related to regulating self-storage facilities. Similar to the last paper, this was inspired by counselors just driving around the community and seeing a plethora of self-storage facilities being put up, many of which provide little to no jobs. There are some construction jobs, during the construction, but after you might have one attendant, you might not have any attendance, the way artificial intelligence is going. I believe this has been sponsored by a majority of the council. In terms of what is the best use for our land in our community, I just don't think this is it. I think that, encouraging businesses that we want, in the location that we want, the type of housing that we want, in the locations that we want, that's what we want to do. By allowing and encouraging more construction of these self-storage facilities, really what we're encouraging is a transience. We're really encouraging and understanding that people, won't really be able to, own a home and age in place, but instead they're going to need to, put their stuff into a storage facility. I do think that really where my focus would be is more owner-occupied housing that we can really construct along, corridors in our community and make it a more livable community. Businesses that actually provide jobs, self-storage facilities are just not that. I know we've been here for a while, so I don't want to belabor the point, but if you have any questions, I'm available.
Okay, Counselor, thank you very much. The only questions I have are right now, it's allowed only in Industrial 1 and Industrial 2. So it's prohibited from all other zones in the city. So we do have a few of them that have popped up in the city. We've got one being built where Lawn used to be. We've got a couple where Boston Steel was, and then the Hostess Factory. So we have seen a number of them. To my knowledge, these provide the same commercial benefits from a tax perspective. And my understanding is they have been relatively problem-free with regard to generating traffic, as far as generating any type of draw on our services within the city. The biggest downfall is the limited number of ongoing jobs that are provided by this group. The other comment I'd make, and I'm curious what your thoughts are, in these days where we keep pushing for more residential in the city, my understanding from this is that this is a direct result of all the additional residential and dwelling units in the city. That's is what prompting these companies to make the investment and try to provide that service, because and I don't have the numbers at the front of my head, but there's a very high percentage of these units that they say we're deficient in, that we should be providing more given the number of dwelling units we have. So I'm just trying to weigh the fact that something that's relatively innocuous for the city and the draws on the city, providing a competitive tax base for us, and it's something that people are saying that we need, that we don't have enough of this stuff. So I do happen to agree with you that when you look at it, is there something better we could do with some of these lots? I don't know what was going to go into Lawn if it wasn't, I'm sure there were other things, but Lawn was vacant, I believe, for a long time down on Easton Ave before it got flipped into this self-storage unit. So those are just some of my comments and what I'm thinking. And if I've got something wrong, certainly point it out, because I see the big negative being it doesn't provide enough long-term jobs that other options might. But I think that it does provide a competitive tax base, and it doesn't draw on city services, and there are very few problems with these units that I've heard about. So those are just my comments. If you want to address anything that I might be off base on, I'd certainly welcome it.
Yeah, I think that my feeling would be when the economy is good, we should be encouraging good development. And that can come in the form of, a Class A office building that is going to provide daytime jobs, that is going to be able to support a daytime density that can support our local restaurants. I am not an opponent to housing. I think that one of the things that we need to do is build the right housing. And again, that comes back to the owner-occupied, affordable housing where possible. You would have no idea how much you can make and still be considered and qualify for affordable housing in the Boston area. It is quite high. I do think maybe it's just a different philosophy. I am also familiar with former Councilor Neil Kinnan and our Chief Strategy Officer Ron Hogan's analysis of the cost that housing brings, particularly in our school systems. As a product of Malden Public Schools, that is something I'm okay with. It's something we need to deal with, and that's why Councilor Murphy and the council is looking for new ways to generate revenue. But I do want a community that people can raise families in, that can send their kids to school and be proud that they're going to Malden Public Schools. I do think there's the way to have both and not settle for what to me feels like a desert. I do think that there's higher and better uses for our property than storing people's things.
Okay, thank you. Does anyone have any other questions for Councilor O'Malley? Oh, give me 1 second, okay. Eric Henry.
Thank you, Mr. Chair. Council, I was just looking, I think I saw the paper that came out of council, and I just didn't notice what the vote was as it came out of council.
Yeah, so there's a procedural vote on the first page. It's right at the top, and it says that the sponsors of this paper are myself, Ward 3 Councilor Amanda Linehan, Ward 7 Councilor Chris Simonelli. Chris Simonelli was a big supporter. A lot of these storage facilities are in Ward 7, and so he was very adamantly in support. Ward 6, Councilor Steve Winslow, and Councilors at Large, Cologne Hayes and McDonald.
So those are all the members on the subcommittee, and they came out unanimous?
These are the sponsors. I believe it was unanimously sent here, but we would then vote after you provide a recommendation. So like your last vote was a recommendation to us. We can take that, we cannot take that. And so we haven't really put an opinion on it aside from sponsorship, which is usually a sign, but I've seen sponsors vote against their papers before.
Yeah,
So Eric, I don't think it's actually come up in front of the council yet. It's just been proposed and went through committee, and now it's in front of us.
right. So I was just trying to, if it's been through committee, what was the vote coming out of committee?
Didn't go to committee.
Oh, so,
I'm sorry, it was proposed and it was referred for planning board and joint, it was referred to the planning board for a joint public hearing with the city council ordinance committee. Sometimes papers do get sent to committee first and then get referred for hearing. This went directly to hearing.
And to clarify, we sent it, we've been doing a joint thing for time sakes. So we sent it to both a joint ordinance and planning board hearing, and we sent it to the ordinance committee where we met and discussed it, but we made no amendments to it. That was mostly because we were up against the clock because of the summer.
understood, thank you.
Thank you.
Okay, thank you very much, Council. Oh, Risa Gray.
Thank you, Mr. Chair. I'm wondering, I don't know if there's any way to know this, but because these are probably, they probably fill up and empty and fill up and empty, but is there any way to tell how much capacity is filled in the list of units that you've got on this chart currently?
I do not know personally. We have been, one of the challenges and one of the reasons why this was also inspired is it's really hard to get a hold of the people. So we've been trying to get a hold, Councilor Simonelli and I have been trying to get a hold of one of the owners of these facilities, and we've not had much luck. So I don't know how we would know. I've seen TV shows where you can buy at auction a storage unit for a price, and then you find out what's inside it. So I think that they probably might not even know, because oftentimes those shows, it's a mystery what's inside. So it's not clear, but I mean, well, they don't know what's inside, but they probably know if it's used or not. So I think that we could try to find that information out, but based on our attempts to get the information from owners for other things, we haven't had much luck. Sorry for my
Thanks. I didn't
mind
know.
fog there for a moment.
Are you all set, Risa?
Yes, thank you.
Michelle.
Yeah, I just wanted to add, I actually put the chart together. So I looked at building and occupancy records. I did contact a couple of the owners directly to find out the numbers because I wasn't clear on the total numbers. This is total numbers of storage units. When I was looking on a lot of their websites, you can see which units are available. So you can, get some sense of whether it's available or not. I will also just refer you back to the most recent case, which the chairman referenced, which was the 950, 970 Eastern Avenue case that was allowed by special permit back in 2021, not that recent. That is where, and I think that the chair was referencing, the developer presented information about the industry standards, and that's where he stated that we're underserved for the number of apartment units we have. And I want to say it was like grossly underserved by that industry number he gave us. I'm not sure I believe that, but he indicated that there's a, you know, metric they use, number of units, how many storage units do you need? And we were like really, really low compared to other parts of the country. That was my recollection of it, if that's what you're referring to.
No, it is, and thank you for adding more clarity to that,
Right.
because, I question, take it with a grain of salt when it's like a traffic study. You know, there's never any problems, or you're always underserved, or whatever. But that's exactly what it was. I know we had it presented to us that we were significantly underserved, and that's why they were proposing to come here.
Right, and I just want to clarify again, this number here I've given you is the total number of units in each of these 9 storage facilities. It's not whether all those units are occupied.
Right. No, thank you for clarifying that, Michelle. The one thing I do know about these things is the price just always goes up. You know, we have one for the Youth Soccer League, and it just creeps up every year, you know, a certain amount every year, and you look at it a couple of years later, and it's significantly more than when you negotiated it. Does anyone else have any other questions for the counselor? Does anyone on the council have a question for the sponsor, or one of the lead sponsor? No? Okay. Well, I guess at that point, Council, you don't have anything else you'd like to add? You all set? Thanks. We'll take, at this point, we'll request anyone that would like to speak in favor of this petition, in this council paper. Anyone to speak in favor? Diane, you have a letter to read in favor? Let me click your mic on. There you go.
Okay, it's actually an email to Michelle Romero dated Monday, July 17th, 2023. It reads, "Hi, Michelle. My name is Benjamin Cook, and I am a resident of Malden at 88 Russell Street. If it's not too late, I wanted to submit a couple of brief comments about the agenda on the planning board meeting tonight, July 17th, 2023. Thank you, Ben. Concerning item 3A2 CCP 198/2023. I support this proposal to prohibit self-storage facilities in the industrial zoning districts. Self-storage facilities contribute to suburban sprawl by encouraging the development of low-density, auto-centric commercial zones, which can lead to increased traffic congestion and longer commutes. These businesses are generally not pedestrian-friendly spaces, and their presence contribute to the lack of activity in the surrounding areas. As a climate justice community, we must take every opportunity to improve the status quo of increased transportation emissions and their contribution to air pollution and climate change."
Okay, thank you very much, Diane. Nothing else to read in favor?
No, I have nothing else.
Seeing and hearing none, declare that part of the hearing closed. Is there anyone that would like to speak in opposition? Anyone in opposition? Diane, do you have anything to read in opposition?
I do not.
Very good. Seeing and hearing none, declare that part of the hearing closed. Is there anything in general that anyone needs to read in? No, nothing in general. Okay. So with both those in favor and in opposition closed, Michelle, can you take us through your staff report, please?
Yes, and I'm reading from the July 17, 2023 Planning Report and Recommendation. I won't read it verbatim, but it's incorporated here and by reference into the record. This is regarding paper 198 of 2023. The proposed amendment, as we've heard, is to prohibit self-storage facilities in the industrial 1 and 2 zoning districts. That would result in a citywide prohibition. As you can see, I've given you the table of use regulations. Self-storage facilities right now are prohibited in all districts except industrial 1 and 2. So if they're now prohibited in industrial 1 and 2, they will be prohibited citywide. They're currently allowed by special permit in those 2 districts. I've given you the definition here. It specifies what a self-storage facility is. I'm not going to read that into the record. The use regulations, as I mentioned, are above. I've also given you a copy of the zoning map so you can see where those districts are. Also included here are the required findings to grant a special permit. The amendment proposes no changes to the existing required findings. I'm not going to read those into the record, but they're here. They're taken from 12.12.010B of the city zoning ordinance. So there are 5 different findings you would need to make. The last 3, 4, 5, and 6 are for all special permits. 1 and 2, you would either do 1 or 2, depending on whether it was new construction or whether it was a pre-existing non-conforming building. In terms of dimensional controls, I've given you the dimensional controls here. The amendment proposes no changes to existing requirements. Parking and loading requirements, amendment proposes no changes to existing requirements. I've given you the requirements here. In terms of the summary, I've given you a brief summary of zoning regulations. Previously, self-storage facilities were considered warehouses. That's how there were a few here on this list that were allowed by right, because at the time, warehouse was allowed by right. Then they became regulated by special permit, or at least warehouses did. That was done through the Board of Appeal. In 2000, the city enacted a moratorium on self-storage facilities so that they could propose some zoning amendments to regulate this new type of use that we were seeing in the city. And that is when we saw the current regs come into play, 2001, slightly modified, but in 2002, when we added the Industrial 2 zoning district to the city, and then in 2007, modified to change the special permit granting authority from City Council to Planning Board. Applications and exemptions, the amendments will apply to new construction, new use and occupancy of existing buildings unless exempt by state law, the city ordinance, or the express language of the amendment, or the subject of a building permit or special permit issued before the first publication of the notice of public hearing, which was June 30th, 2023. So there is one project that's exempt from the proposed amendment. There is a building permit and special permit issued prior to the date of first publication of the hearing notice. That is the project we've mentioned, 950, 970 Eastern Avenue. There are no applications in the processing stage that we need to talk about. In terms of existing self-storage facilities, all illegally existing self-storage facilities will be exempt from the amendment. They will become pre-existing non-conforming uses if this amendment were to pass. That is where the chart comes in. That's on the fourth page of the staff report. You can see the address, the zoning district, what type of zoning relief was required, or if it was allowed by right, square footage, height, number of storage units, number of parking spaces, and loading spaces. That's just for your reference. The effective date of the amendment would be when the City Council votes to ordain the amendment. The City Council must act within 90 days after the public hearing closes. Otherwise, a new hearing must be held. So if the hearing closes tonight, the final date for action is October 15, 2023. Your standard of review and recommendation of the proposed zoning changes should be directed by substantive planning objectives, community need, and general welfare. The amendment is not supported by any known substantive planning objectives, community need, or general welfare. Self-storage facilities do add to the city's commercial tax base, typically have limited traffic impacts and no impacts to the neighborhood, and may be properly regulated through the existing special permit use regulations. Again, you would be making an advisory recommendation to the City Council. The City Council will decide whether or not to amend the zoning ordinance. Your recommendation is non-binding. However, if it is to disapprove, it will have the effect of prohibiting further review of a similar amendment within 2 years if the council ends up voting unfavorably. Do you want me to give the recommendation?
Yes, please.
So the recommendation made prior to the public hearing is that the planning board recommend to the City Council disapproval of the proposed amendment of section 12.12.03, which is regarding self-storage facilities.
Thank you very much, Michelle. Michelle, quick question for you. Do you know how many dwelling units we have that would be considered apartments or multi-family? I know we got about 27,000 units.
That's total housing units.
Right.
Probably I do have it somewhere,
Okay, no,
but I don't have it right here.
I didn't think to look this up earlier because.
You want to know how many are apartments, how many are rental?
Yeah, rental, because I guess what I was thinking of as we were talking about it, we had a developer come in and tell us we were underutilized. I don't know whether we are or not. But, I mean, based on 27,000 units, you compiled a list of almost 4,700 units available, right? That's 17% of our housing units. I suspect that our apartments are probably in the 13,000 to 15,000 range. You know, so the question becomes, is a third of our estimated apartments having enough to accommodate a third of those apartments enough? Is that enough capacity that we want to absorb in the city? I think we need to offer it someplace in the city. So I don't know that I'm in favor of recommending that we eliminate it from both of them. But I guess I'm just trying to get my head around what we've got capacity for now based on our rental units versus what others are telling us is insufficient.
Yeah, I'm looking for it. I know it's here in this housing needs assessment. I just have to find it. So this is from 2019, which was the housing needs assessment, just to give you a sense. So it said 59% of all households in Malden are renters.
Okay.
But I don't know if that's 59% of all households. I don't know if that's the same as 59% of the total housing units. I
Right.
think there's a difference, so let me see if I can get you a different
Well,
number.
presuming it's in that ballpark, that's about the 15,000 that I had.
Okay.
Kind of just
Okay.
ballparked from that end. And so the question is, do folks think that a capacity to accommodate a third of the rental units, is that enough? I mean, waiting to see what happens with this MBTA zoning, who knows, that could be a whole different animal. But just based on where we sit right now,
Yeah, this was saying housing stock, 27,300, this was at the time. Less than 1/3 was single-family homes. More than a quarter, so 28% were single-family, 26 were two. 31% were in buildings with more than 20 units. Again, though, I mean, this isn't telling you who's renting, two-family, could both units be rented or just one? A single could be rental, you really want to know.
yeah, no,
rental
this
units,
is,
yeah.
for me, this is close
Yeah.
enough, because if it's a third, then that brings us down to 16,000 units, where I was throwing around 15,000.
Yeah.
And it's just to get an idea of what our current capacity is, and is that enough? Because actually, it just comes back to, I think we need to offer it someplace in the city. Offering it in industrial seems to feel right to me. So I don't know that wiping it out of every zone is appropriate. Does anyone have any comments, or? Eric Henry.
Thank you, Mr. Chair. Personally, I'm thinking about this, and I'm thinking about the zoning. We essentially said that the city would not allow Airbnbs to come into the city. So now we're looking at shutting down a whole nother business opportunity to come into the city as well. Excuse me. And I could not help but notice that, referring to that last paper that came before us with the storage facility, Councilor Winslow was the prime mover, supporter of that paper, and now he's also a supporter of this paper here too. So I did note that as well. But I think I kind of agree with you, to totally eliminate it would be, especially about population, is a transient population in Malden. Those figures are about, I've always gone on the figures that about 60% of our population was a transient population in Malden. So I don't see, I don't see that changing much in the future. So thank you.
Thank you, Eric.
I just want to clarify the record, you're referring to the fact that Councilor Winslow is a sponsor of this paper, and he spoke in support of the 950 Eastern Ave proposal. Okay, thanks, because that's his Ward 6, right? Okay, thanks.
Stephanie Stoll.
Yeah, with the MBTA proposal, I think part of one of the solutions was to put some part of industrial into residential. That was part of one of the proposals. So some of the industrial land now could be residential, and us both recommending not to amend industrial or to amend it. Like, it wouldn't affect changing industrial into residential. That wouldn't do the 2-year kickoff for amendments.
The MBTA zoning, I think one of the scenarios, but I don't think any part of the scenario that's currently being worked on, the current draft, proposes to convert, I'm sorry, I'm misspeaking. So there is land that's being proposed in this MBTA zoning. That's a separate zoning amendment, though, if and when it comes to you. So this, I think you're saying, if you recommend disapproval of this to prohibit self-storage facilities, is that somehow going to affect that? And I would say no. What the provision reads is the council can't consider the amendment on its merits within 2 years. Mm-hmm. So there couldn't be another proposal to prohibit self-storage facilities in industrial 1 and 2 for 2 years. Mm-hmm. Again, and that's if the council acts unfavorably. So if you recommend disapproval, it goes back to the council. If they end up approving it, obviously there's no issue. If they end up disapproving it, then it would be a 2-year prohibition to bring that same or similar paper back. But no, the MBTA zoning is a separate thing. And it could go over parts of industrial 1 and 2. And it will override, or not override, but it will supplement existing zoning. So somebody would be able to build under current zoning or under this MBTA zoning, because it's being proposed as an overlay.
Okay.
So it wouldn't change. Whatever happens tonight, that will be its own set of rules.
Okay. You okay, Stephanie?
Yeah, thank you.
Anyone else have any other questions or comments for Michelle? Does anyone from the city council have any questions or comments for Michelle? No? Okay. If there are no other questions, is there a motion? Diane Chuha.
I make a recommendation that we agree with the planning recommendation to disapprove it.
Okay, so Diane's made a motion to support the recommendation of the planning staff to advise the council to disapprove the change proposed in the paper.
To recommend disapproval.
To recommend disapproval to the paper. Is there a second for that? Eric McCush.
I'll second that motion.
Eric seconded it. Okay, let me,
So a yes vote is to recommend disapproval.
yes.
Yep, Diane Chuha,
Yes.
Tawadish Gabrasalasi,
Yes.
Risa Gray,
Yes.
Eric Henry,
Yes.
Eric McCush,
Yes.
Henry Susi,
No.
Stephanie Stone,
Yes.
Ronnie Raj Verma.
No.
Chuck Oven.
Yes.
So that was 7-2. You needed a majority to make that recommendation, so that passed. We will make that recommendation. I'll make it on your behalf, and I will note what the vote was.
Okay, thank you.
Thank you.
Okay. 9:19 p.m. Okay, so the next paper that we're going to take up is Council Paper 227/2023 regarding banning drive-throughs. Councilor O'Malley for the paper.
I apologize for being the only one up here tonight. Again, my name is Ryan O'Malley, Ward 4 City Councilor. This was in tandem with the original paper that we discussed tonight, but it is a standalone paper that would, I think, be a good change. Again, it's about right-setting our zoning so that people who are looking to do projects understand what they're getting into and know that they'll have the support of the community when they do it. I don't want anyone to waste their money. I don't want anyone to waste their time. I want them to be putting forward good projects that people can get behind and actually going to improve our community. So this is looking to change SP to no for drive-throughs in neighborhood business, and Again, you heard, many of the residents actually came out, and when they spoke, they were kind of speaking on this paper in addition to the last one, so you heard that testimony. And I might have maybe changed one of your minds had I pointed this out more clearly in the earlier one. But, you know, drive-throughs is just one of the things that would have been changed on the other paper. You know, and it's really about making sure that what you have next to other uses makes sense. And so, like, I don't think that a drive-through necessarily makes sense in a neighborhood business type setting. I don't think that's something that makes sense on like Upper Main Street. I don't want to belabor the point, and I appreciate your support. Thank you.
Councilor, the only question I have is, what about the commercial business area?
Oh, yes.
I see your point and I understand your point on neighborhood business, but what about, because I'm thinking Stop and Shop, Walgreens, several banks, all in the commercial business district have drive-throughs already, and would that limit going forward?
My analysis is that there are no drive-throughs in central business. I don't think that there are. Is Walgreens? Oh, maybe Walgreens. Yeah, Walgreens.
There's Walgreens,
That'd be
also the
pre-existing.
CVS, also the CVS at Ferry Street, that's central business.
No, that's.
Yeah, I've given you a list on page 3 of recent, so some, I know that the boundaries have changed here and there, but.
Yeah. But basically from Michelle's list, and the only one in neighborhood business at the moment is Beach Street, the Dunkin' Donuts on Beach Street, Beach and Lynn. And then the ones in central business are Eagle Bank on 180 Easton Ave, Wendy's. What's that,
Those
Michelle?
never went forward, I'm sorry. I listed them, but they never went forward.
Yeah, so if I remember correctly, I've always been confused about why south of Route 60 is central business. So like, I think that when you think about Walgreens and CVS, those are more highway business, but they are zoned as central business. That's a quirk that came before my time. They're pre-existing non-conforming, so they would still be allowed to continue. But when you think about what central business is, you think about it being walkable. You think it being near the train. And you know, we used to say, or it used to be said in the city that, you know, Starbucks wouldn't come to Malden unless it had a drive-through. Well, we proved that wrong. Starbucks opened up. It doesn't have a drive-through. And yes, to Councilor Spatafora's point, you know, is there an added Uber and Lyft situation? Yes, but that is going to happen to any business, regardless of whether or not it has a drive-through or not. So I do think, you know, in the downtown, we really want it to be walkable. We want it to be serving people who are living in the downtown, and really make it something that you're encouraged to walk around and patronize the businesses. But yeah, you're right. Walgreens and CVS are kind of outliers, but I think it's because they're really on the edge of the central business.
And Michelle, correct me if I'm wrong, but a part of this whole drive-through thing is there a series of dimensional controls that need to be satisfied also?
Yes. There are special permit regulations, and then there are drive-through, what we call dimensional controls. They're actually in the parking requirements section. But if, you know, they're prohibited in the district, they wouldn't be able to go in either way, you know.
And so I appreciate your time. If you do have any questions, I'll be here, same as the other ones. I do also want to mention, like, I know it's very tiring seeing me up here all the time. Our ordinance and state law actually does allow the planning board, the zoning board of appeals, any individual who would be impacted by zoning, 10 residents, to file zoning amendments. So if you see something when you're out there, maybe my ideas are not the best ideas, which is probably true. I think many people would say that. If you have an idea about a zoning amendment that you would like to see, I do encourage y'all, with your expertise in building and real estate, et cetera, to propose those. Propose it to the planning board. We would have a hearing like this and discuss it, just so it's not me or the counselors up here always yapping at you. But I do appreciate your time. Thank you.
Thank you, Councilor. Okay. Councilor O'Malley's finished his presentation. At this time, I'll ask if there's anyone that would like to speak in favor of this petition. Anyone in favor? Diane, I believe do you have something to read in favor?
I have an email to Michelle Romero dated Monday, July 17th, 2023. It reads, "Hi, Michelle. My name is Benjamin Cook, and I am a resident of Malden at 88 Russell Street. If it's not too late, I wanted to submit a couple of brief comments about the agenda for the planning board meeting tonight, July 17th, 2023. concerning item A3 CCP 227/2023. I support this proposal to prohibit drive-throughs in the neighborhood business and central business zoning districts. Drive-through businesses are contrary to the principles of creating vibrant, walkable, and sustainable communities. These businesses also disproportionately cause local traffic congestion and encourage driving for short trips, which are issues that already plague Malden's business districts. As a climate justice community, this is yet another important opportunity to build for the future instead of perpetuating the injustices of the past.
Okay, thank you very much, Diane. Is there anyone else that would like to speak in favor? Seeing and hearing none, declare that part of the hearing closed. Is there anyone that would like to speak in opposition? Anyone in opposition? Diane, do you have anything to read in opposition?
I do not.
Thank you. Seeing and hearing no one else in opposition, declare that part of the hearing closed. Michelle, do you have anything in general? No. Okay, so nothing in general. Very good. Could you, councilors, do you have anything you'd like to add, Ordinance Committee? Okay, then we will move on. Michelle, take us through your staff report, please.
So this is dated July 17th, 2023. It's the planning report and recommendation. I won't read it verbatim into the record, but it's incorporated herein by reference into the record. We heard about the petition to prohibit drive-throughs in the neighborhood business and central zoning districts. You can see the table of use regulations I've provided here in the report. So currently drive-throughs are prohibited in residence A, B, and C residential office zoning districts. They're currently allowed by special permit in all the business zoning districts and the 2 industrial zoning districts. Under the proposal, they would be prohibited in central business and neighborhood business zoning districts. They would still be allowed by right in highway business, industrial 1 and 2. Given you, there's also a subsection that contains specific findings for specific use regulations for drive-throughs. And it talks about how they're accessory to principal uses, restaurant, general offices, convenience store, supermarket. They require a special permit. The definition is here. I won't read that into the record. I read it once earlier. The use regulations are here. I've also given you the zoning map so you can see where those districts are located. The required findings to grant a special permit. No changes are proposed to these required findings. I've provided them here for your reference so you can see how these uses are regulated. Parking requirements. There are parking requirements in terms of dimensional controls for the width and exclusive lineup area. So these requirements were established in 1985. And then in 2004, we added the special permit use regulations. The amendments aren't proposing any changes to the existing requirements in terms of the width or length of the lineup area. Prior to 2004, drive-throughs weren't regulated. They were allowed by, at least not as a separate use, they were allowed by right in all zoning districts. They were subject only to that lineup requirement, width and length. 2004, we did the special permit regs. There was a brief period where we tried to regulate them under site plan review. We went back to the current special permit regs in 2010. In terms of the application and exemptions, the amendments will apply to new construction, new use, and occupants of existing buildings unless exempt by state law, the local ordinance, or the express language of the amendment, or are the subject of a building permit, special permit issued prior to the first publication of notice of the public hearing. There is one application that is considered to be in the processing stage. It was filed prior to the first publication of hearing. That is the petition we heard about, which is a fast food restaurant with drive-through at 1100 Main Street. So that is located in the Highway Business Zoning District. So it's not the subject of these amendments, but if the other proposed amendment that we already heard about to reclassify that district to neighborhood business, to reclassify that property to neighborhood business, then it would apply to this property, and drive-throughs would be prohibited at that property. Giving you a list here of the special permit, the drive-throughs that were permitted under existing special permit or site plan review regs. So pretty much anything else in the city that has a drive-through predates these regs. So if you're wondering how or why they exist, it's because they were allowed by right. Effective date, the amendment is the date the city council votes to ordain the amendment. The city council must act within 90 days after this hearing closes, otherwise a new hearing is required. So if it closes tonight, the final date for action is October 15, 2023. Standard of review and recommendations. Your standard of review and recommendations of the proposed zoning changes should be directed by substantive planning objectives, community need, and general welfare. The amendment does not appear to be supported by any known substantive planning objectives, community need, or general welfare. Drive-throughs are an appropriate and important option for various businesses. Existing special permit use regulations properly regulate drive-throughs in all business and zoning and industrial zoning districts where currently allowed. Again, you'd be making an advisory recommendation to the city council. It's the city council that decides whether or not to amend the ordinances, and your recommendation will have, is non-binding. However, if it is to disapprove, it will have the effect of prohibiting refiling or prohibiting consideration of a similar or the same amendment within 2 years if the council ends up acting disfavorably. So the recommendation is that the planning board recommends to the city council disapproval of the proposed amendments of sections 12.12.030 and section 12.12.150, which are the proposed amendment to prohibit drive-throughs in neighborhood business and central business zoning districts.
Thank you, Michelle. Risa Gray. Ronnie.
I just had more of a question on 275 Center Street. Isn't that the point, the apartment complex? Since it's a Wendy's?
Yes, that property is 180, is known as 180 Eastern Ave. That's an apartment building. But at one point, it was permitted for a bank with drive-through and a Wendy's with drive-through.
Okay.
But they never exercised those permits, so
Okay.
they were never built.
You all set, Ron?
Yeah, thank you, Mr. Chair.
Councilor Murphy?
Do you want me to wait till the planning board?
No, you can wait.
Um,
Don't feel compelled to look, we won't be offended.
No, I just, just in looking at this and hearing, the residents that came in tonight and just thinking, long-term about anywhere there's neighborhood businesses, that you probably would have the same reaction from the general public in coming out to say they did not want to drive through in their area because, of all the safety issues we heard tonight. And I just, looking at this in my mind, I think it might make sense to kind of split this down the middle here and stick with a no on neighborhood business and then have a special permit remain in central business. So that was just kind of my thought process, because I don't think you're going to get a lot of pushback in central business, but neighborhood business, that's really where you have residents so close to people, and you're going to get folks concerned about their children riding bikes and walking the dogs and everything that we heard this evening. So just didn't know if anyone was thinking along those lines and if anyone would want to make a recommendation to maybe change the, make it a friendly amendment to what's in front of you. So, my 2 cents. Thank you.
Oh, thank you, Councilor. I was thinking the same thing. I really don't see a lot of central business that doesn't already exist there. And what I would be concerned about would be things like less about fast food, less about the coffee shops, more about things like banks or pharmacies or something that's geared towards central business but isn't part of something we've already seen. I tend to approach this as where do I think we should have them. One of them is, I think, Lower Broadway, parts of Eastern Ave. As I look at Commercial Street, areas like that, that's where I look at it. I don't see this, I don't think we should have anything in neighborhoods. I think the Dunkin' Donuts are always a problem. Every one of them that I've ever seen has been a problem with regard to the drive-through. So and I know Dunkin' Donuts are considered a restaurant for the purposes of how we view them, but that's how I look at it. And looking at the map that Michelle provided, most of the places I look at and think of what could and should accommodate a potential drive-through is highway business, Industrial 1, Industrial 2. Now, the way it sits right now, that includes Upper Main, but that's not necessarily where and hearing the neighbors tonight, that's not where I consider it. Like I said, I'm talking Lower Broadway, where we already have McDonald's, we already have Burger King, Kentucky Fried Chicken. I could see parts of Commercial Street after the train station possibly accommodating a drive-through, probably even south of Charles more than anything, and possibly parts of Eastern Ave. Like if you think from 180 Eastern Ave down to maybe the cemetery. Those are the areas where I think, as long as they have the other parking controls that Michelle referred to earlier, that's where I would feel comfortable and where I think we should be seeing drive-throughs. Not in neighborhoods, and as I mentioned earlier, not to beat a dead horse, but that Upper Main Street neighborhood, once Fidelity built all those units and PV speed went out, that neighborhood changed. That's not what it was when I was going up to soccer practices up at Pine Banks. Stuff like that. So those are just some of my comments. I see some other people want to weigh in. Eric McCush.
Thank you, Mr. Chair. I would just like to echo your, the previous sentiments. It makes a lot of sense to have it in central business, but not neighborhood business. Do we have the right to split that?
Yes.
Okay.
You can make a recommendation that recommends approval in part and disapproval in part, or approval in entirety or disapproval in entirety.
Okay, thank you.
Okay, and Councilor Spatafora.
Yeah, thank you, Mr. Chair. I don't want to be repetitive, but I agree with everything you said, and I think the other practical purposes, and the recommendation of splitting is great, is, I've heard, there was one gentleman who spoke about the automobile and getting rid of that, and I have no problem with that, that's his opinion, but at the end of the day, we're not getting away from automobiles, right? Whether it be electric vehicles or combustion engines, they're here to stay. And then realistic, as a parent of 3, I can't go food shopping on a bicycle. Like, I can't walk to buy enough groceries. And I don't say that to be mean, but there's still going to be a need for that. The reason why I mention that is because if you were to eliminate all drive-through options, forget the fast food, banks and pharmacies, I would leave the city to get my daughter's medication because, I have 3 young kids. I'm not going to leave them in the car, right? And I'm not going to pack them all up to go out of the car, especially when it's the wintertime. The convenience factor of having a pharmacy or a bank is a necessity. And I think if we just eliminate that option going forward, that's going to leave a big need for a lot of people. And then you look at the other side of the spectrum. You have the elderly. They don't want to get out of their cars to get their medical needs or their pharmaceutical. So, I was going to say COVID for everything. I mean, that's why everybody's gone to drive-throughs. So I agree. I think you can split them down the middle, have the option. Again, with all the regulations that are needed, I completely agree with the Dunkin' Donuts. But just I think you have to have optionality for certain uses. And I certainly don't want to see fast food everywhere. But I think if we eliminate it all together, it's going to create an unneeded burden on people that are going to need it, whether they're being, family, single parents that you can't get. I mean, the challenge of taking 3 kids, they're a little bit older now, but the 3 kids into a store was the worst part of my life, right? You have to get them all out of the car, you got to put them all back in there, make sure they're the seatbelt. That's a long process. And having that American way of being a little bit lazy and that affordability to get up and drive through and get that stuff is a need for a lot of people. And I think by us being very prudent, splitting that down the middle, but allowing it for certain needs, I think is the way to go. So I think that's a good compromise, and hopefully the petitioner sees some of that and we can move forward.
Thank you, Councilor. Any other comments or questions for Michelle? Is there anyone that would like to make a motion? Eric McCush.
Thank you, Mr. Chair. Yes, I'd like to make a motion to disapprove the banning of drive-throughs in commercial business, but approve the banning of drive-throughs in the business neighborhood as a recommendation to the council.
Okay, so Eric suggests we change the paper, recommend that the council consider changing the paper as submitted to continue to allow it in central business, but not allow it in neighborhood business.
Correct.
Eric Henry.
I can second that motion.
Eric Henry has seconded that motion. Yes. So
Yes.
basically, the only change would be, as the paper is submitted, would be to change it in neighborhood business from special permit to no. So that in ABC, residential office and neighborhood business, drive-throughs would not be allowed. However, by special permit, central business, highway business, and industrial 1 and 2.
So a yes vote will be to recommend to the city council disapproval of the paper regarding central business and approval of the paper regarding neighborhood business.
Got that?
Diane Shuha?
Yes.
Tawadich Gebrselassie?
Yes.
Risa Gray?
Yes.
Eric Henry?
Yes.
Eric McCush?
Yes.
Henry Susi?
Yes.
Stephanie Stone?
Yes.
Ronnie Raj Verma?
Yes.
Chuck Iovan?
Yes.
So that 9-0, so that you needed a majority to make that recommendation. We'll make that to the city council.
Okay, sir. Okay, very good. I'll pass it over to the Chair of Ordinance, Councilor Crowe. Do you have any comments? Do any of the other councilors have any comments, or do you want to adjourn?
Motion to adjourn. Second by Councilor Spatafora.
I'll second that.
All in favor? Aye. Any opposed? Adjourn.
Thank you all very much for staying and hanging in there tonight, and we'll see. Yeah, we're not sure, because I know we have a full August.